Ignoring the Constitution is not a requirement to protect and defend shipping lanes on the ocean. And we've got a great example today from the founding generation. When French warships were actively attacking American shipping, they seized hundreds of American vessels. President John Adams didn't just panic and throw the Constitution in the trash. Instead, he followed it closely and repeatedly deferred to Congress for instructions and authorization, and he still got the job done. So on this episode, I'm going to break down the forgotten and almost totally and completely ignored history behind war powers and the Constitution, and how it all played out during the so-called Quasi-War with France. But first of all, before getting to that, welcome, and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Friday, March 28th, 2025. Let's kick it off here with an article by Mike Meharry. He writes, when France and England went to war after the French Revolution began, the U.S. declared its neutrality. However, things did not stay neutral for very long, because in 1793, there was actually a dispute with the French over debt repayments from the United States. And then in 1794, we got the Jay Treaty with Great Britain, which was kind of meant to settle some old disputes and basically promote trade. But the French were not too happy about that. Mike says they viewed that treaty as an alliance between the United States and Britain, who was their enemy at war. They also argued that it violated the Franco-American Treaty of 1778, which was in essence, especially as they saw it, a defensive alliance against Great Britain. So the French definitely saw this as the United States taking sides in a war, and so they treated it like that. And Mike points out that in retaliation, French privateers began seizing U.S. vessels trading with Britain in the Caribbean and along the U.S. eastern seaboard, and they went nuts with this. By the summer of 1797, this is John Adams' first year in office, the French had seized over 300 American vessels. So this is pretty significant. And in the spring of 1797, President Adams thought it was so serious that he actually called a special session of Congress to discuss these mounting tensions with France. And in his message, it was May 16th, 1797, President Adams explained the whole reason for this special session. He said, in giving to Congress information of the State of the Union and recommending to their consideration such measures as appear to be necessary or expedient according to my constitutional duty, the causes and objects of the present extraordinary session will be explained. And so he was clear over and over that it was up to Congress to authorize private ships to defend themselves and more. He said it remains for Congress to prescribe such regulations as will enable our seafaring citizens to defend themselves against violations of the law of nations, and at the same time restrain them from committing acts of hostility against the powers at war. The United States, pretty young at this point, was really not interested in getting involved in a major war going on between France and Great Britain, and of course, a few others as well. But this was very important. They wanted to be able to defend themselves and not get dragged into the greater conflict. Now, John Adams really was just reaffirming or affirming the widely held founding era view that all of these decisions are really up to Congress, except for a very narrow exception. We're going to get to that in a little bit as well. A few years earlier, the first Chief Justice John Jay explained it best, in my opinion. He said, until war is constitutionally declared, the nation and all its members must observe and preserve peace and do the duties incident to a state of peace. So back to John Adams and that special address. He also urged Congress not just to empower private citizens to defend themselves, but he also wanted Congress to build up naval defenses. He said, in addition to this voluntary provision for defense by individual citizens, it appears to me necessary to equip the frigates and provide other vessels of inferior force to take under convoy such merchant vessels as shall remain unarmed. So we got to start protecting our people because commerce with the world is such a big deal. I mean, if you think back, just as a quick aside, to all of the complaints throughout the American Revolution, Thomas Jefferson was so very clear in his summary review of the rights of British America in 1774. All these external regulations going back almost a full century, many of them saw as totally unconstitutional, not just the internal taxes. So trade was a very important part for the young republic. Now, instead of actually allowing private self-defense, Congress followed up with this on June 14th, 1797, and expressly banned it. They said, no way can you do this. And if you do, you're going to be punished, quote, punished by a fine not exceeding $10,000 and imprisonment not exceeding 10 years. If any citizen or citizens of the United States shall, without the limits of the same, fit out an arm or attempt to fit out an arm or procure to be fitted out and armed any private ship or vessel of war. This was an act to prevent citizens of the United States from privateering against nations in amity with or against citizens of the United States. So they actually prohibited this. And then a few weeks later, July 1st, 1797, Congress actually granted some of John Adams's requests and passed legislation to provide for limited naval armament, authorizing the president to basically man and employ 3 frigates. This was called an act providing a naval armament, July 1st, 1797. So later that year, in his first annual message to Congress, this is November of that year, President Adams said negotiations with France were not going too well. They were trying, but they were having some problems. And he actually expressly said he did not think that this was going to be resolved very well. And it was going to end up a situation where they're going to have to meet force with force, in essence. And here's how he put it. Under this view of our affairs, I should hold myself guilty of a neglect of duty if I forbore to recommend that we should make every exertion to protect our commerce and to place our country in a suitable posture of defense as the only sure means of preserving both. Now, by March of the following year, so now it's basically a year in from that special message, March of 1798, John Adams had received some dispatches from American envoys over in Europe, primarily France. And in another special message to Congress, he explained the situation, that the diplomatic mission had totally failed. This was not going to work. So he again requested authorization from Congress to do something more than just try diplomacy. He said, under these circumstances, I cannot forbear to reiterate the recommendation. So again, he's coming back to him. We got to do something, guys. To reiterate the recommendation, which have been formally made, and to exhort you to adopt with promptitude, decision, and unanimity such measures as the ample resources of the country afford for the protection of our seafaring and commercial citizens, for the defense of any exposed portions of our territory, for replenishing our arsenals, establishing foundries and military manufactures, and to provide such efficient revenue as will be necessary to defray extraordinary expenses and supply the deficiencies which may be occasioned by depredations on our commerce. In other words, come on, Congress, we've got a major problem. Mind you, again, by the summer of the previous year, the French had already seized 300 plus vessels. I don't know the number it was by this time in March of 1798, but I'm sure it was pretty significant. And after all that, finally, Congress agreed to a point. A few weeks later, it's April 30th, 1798. They did authorize a naval buildup, kind of. They created a Department of the Navy to oversee it in the executive branch, and it was going to be under the direction of President Adams. Still very limited. And here from Mike Meharry, he points out that the arming of ships left open the question as to what actions the captains of these armed vessels could take. And what went down? Well, Secretary of War James McHenry wasn't really sure what could be done. So he reached out to his buddy, Alexander Hamilton, and said, well, what can we do? Here's a letter of May 12, 1798 from McHenry to Hamilton. He said, I shall, in a short time, be able to get to sea 1 or 2 of our frigates, and perhaps in less than 6 or 7 days. Can you spare an hour or two? I love how casual this is. Can you spare an hour or two to help me to the instructions that it will be proper to give to their captains? Our ships of war, it is probable, will meet with French privateers. And he said some of these privateers might have already kidnapped some of our citizens, some of our merchantmen. So we may come across some of our merchant vessels with French on board, basically running the ship. He said they may also, when acting as convoys, be obliged to employ force to protect their convoy. May 12, 1798. A few days later, Hamilton provided a response that's actually, I would say, a constitutional approach that's far more limited on war powers than probably anyone in at least a century, if not longer. He said, not having seen the law which provides the naval armament, this is an update for that one. He said, I cannot tell you whether it gives any new power to the president, that is any power whatever with regard to the employment of the ships. But if not, so unless they expressly authorize some additional power, and he is left on the foot of the Constitution, he said that he has no other power than merely to employ the ships as convoys with authority to repel force by force, but not to capture, and to repress hostilities within our waters, including a marine league from our coasts. So without express authorization from Congress to take any offensive measures, this was the line in the sand on what counted as defense on the open seas to even Alexander Hamilton, the biggest big government of the guy of the founding generation. And he said all they could do is repel force by force. In other words, use military force when military force is actively being used against you. And even if you win a battle, you can't even capture the ship that's been attacking you. Basically, that's it. And repress any hostilities in our waters up to one marine league outside of our own waters. He said anything beyond this must fall under the idea of reprisals and requires the sanction of that department, which is to declare or make war. In other words, gotta go to Congress. So the following day after getting this insight from Alexander Hamilton, the Secretary of War, McHenry, gave that same advice to President John Adams. He said, it is thus evident that the President, as Commander-in-Chief, cannot employ these vessels or the Navy in acts of war previous to war being declared by the Congress, nor in acts of reprisals short of war for the same reason, Congress alone having the power to authorize the one or the other. Then he specifically cited a number of acts of Congress and reminded the president that none of them had actually authorized anything beyond repelling force with force. Nothing authorized the president to use the military, the Navy, or anything for acts of reprisals. And he said, from the foregoing laws, the president cannot derive authority to do more than employ the ships as convoys, nor extend the instruction to their commanders further than to repel force by force by force, not including the power of capture or even the exertion of force a moment longer than it is employed against them. You cannot use force in a defensive situation under the Constitution without authorization from Congress beyond defense. And defense means not a moment longer than the force is actively being employed against them. Here from Mike Meharry, he points out that John Adams apparently closely followed this advice, according to historian Abraham Sofair in his book, War, Foreign Affairs, and Constitution Powers. This is if you really want to kind of dive deep into this kind of stuff, you're going to get all the details and the footnotes and the sources and all that. Adams issued narrow instructions to a Navy captain saying operations must be, quote, partial and limited. And Mike continues, as Sai Prakash summed it up in his Virginia Law Review paper, this one's awesome as well, Unleashing the Dogs of War, what the Constitution means by declare war. Prakash said Adams authorized defensive measures and did not even permit the general capture of French ships or any other offensive operations. Now, I'm citing all kinds of stuff, source documents, special addresses from John Adams to Congress, letters from Hamilton and McHenry, plus articles by Meharry and others. All of this stuff is going to be included in a blog post for this episode over at 10thamendmentcenter.com/path-to-liberty. My buddy Alan Mosley does an awesome job getting the blog post organized based off my notes, so hopefully I do a pretty good job on that as well. And he includes a show links section that includes all the reference links that I'm mentioning in the episode, generally in the order that I cover them in the show. That way, you can read and learn more in context on your own time, because I'm really just scratching the surface. Again, Alan will get that organized, and I will get it published over at 10thamendmentcenter.com/path-to-liberty a couple of hours after this live stream is done. But let's get back to it, because even after that, relations between the United States and France continued to deteriorate. It was really a serious problem. And on July 7th, 1798, John Adams signed a law that officially ended all treaties with the French. So there's no question anymore about whether or not there was a defensive alliance with the French. That was definitely over. Here from the act passed by Congress, whereas the treaties concluded between the United States and France have been repeatedly violated on part of the French government. They saw France as violating the treaties. The French saw the United States as violating the treaties. I guess this is the type of thing that happens when you get involved in other countries' stuff. But they say, under the authority of the French government, there is yet pursued against the United States a system of predatory violence, infracting the said treaties and hostile to the rights of a free and independent nation. So be it enacted, the United States are of right freed and exonerated from the stipulation of the treaties and of the consular convention heretofore concluded between the United States and France. And again, that was signed by John Adams on July 7th, 1798. And literally 2 days later, Congress passed an act empowering President Adams to go beyond those purely defensive measures. Maybe, I guess, and I've read through some of these debates in Congress, but they were basically saying, well, we have to officially end the treaty before we can do this. So he authorized, or in this act, they authorized U.S. vessels. The President of the United States shall be, and he is hereby authorized to instruct the commanders of the public armed vessels, which shall be employed in the service of the United States, to, quote, subdue, seize, and take any armed French vessel which shall be found within the jurisdictional limits of the United States or elsewhere on the high seas. So this is the first time. Here it is, all the way in July of 1798 on the 9th, they're finally authorizing him to do something more than a year after it had been reported that they had seized over 300 American vessels. But Adams didn't just say, well, this is an emergency. I got to protect our people. I got to just do whatever I think is best because, I'm following the will of the people. The people chose and voted for me, so I'm protecting them. No, his job was to follow the Constitution. Now, we can set aside the fact that he didn't follow it on some other things, but on this, the example is very, very strict. And so Meharry points out that only after this authorization from Congress did President Adams authorize U.S. ships to engage French privateers with offensive measures. And in February of 1799, Congress expanded that authority, allowing U.S. ships to seize any ship rather than just an armed French vessel, which was the original act, that was engaging in commerce between any person in the United States. It's amazing. They were still conducting trade, or still trying to. So they could seize any ship rather than just an armed French vessel engaging in commerce between the United States and France and its West Indies colonies, regardless of the owner's registry. And then Congress also went a little bit further. They finally gave the president retaliatory powers in March of 1799, but still only in response to very specific French actions like the imprisonment or impressment or corporal punishment of American citizens. It was not a blank check, even at this point, again in March of 1799, and it required proof. But it said, "It shall be lawful for the President of the United States, and he is hereby empowered and required to cause the most rigorous retaliation to be executed on any such citizen of the French Republic as have been or hereafter may be captured in pursuance of any of the laws of the United States." Again, approved on March 3rd, 1799. Now, going into 1800, we're almost into 3 full years since John Adams's first special message in 1797. Congress was still in charge. They kept directing things step by step. And on February 27th, they passed an act to further suspend commercial intercourse between the U.S. and France and all their dependencies. They were still doing trade, and they're really shutting it down at this point, finally, by February 27th of 1800. And then on April 22nd, 1800, I did skip mentioning before that they finally authorized private merchant vessels sometime summer of 1798, around June, to arm and defend themselves. But it had an expiration and had to keep getting renewed. And they finally renewed that as well on April 22nd, 1800, authorizing them to continue to arm and defend themselves against the French. Now, even though Congress never, ever passed a single act, a single resolution or statute, nothing that used the term declare war. They never passed anything that broadly declared a full-scale war, as most people think of it today, against France. It was still widely understood by almost everyone that even these limited hostilities required authorization from Congress under Article 1, Section 8, Clause 11 of the Constitution. This is the declare war clause. And President Adams made this very clear in a letter to future Chief Justice John Marshall. He asks first, questions of consequence will arise, and among others, whether the president ought not at the opening of the session to recommend to Congress an immediate and general declaration of war against the French Republic. So he's wondering, we've been doing all these things. Maybe it's not going to bring us to the end result that we want. And do you think I should actually ask Congress for a general declaration of war rather than these smaller steps? He said, Congress has already, in my judgment, as well as in the opinion of the judges at Philadelphia, declared war within the meaning of the Constitution against that republic under certain restrictions and limitations. President Adams was referencing a case that hit the Supreme Court also that year in 1800, Bass versus Tingey. I'm not sure if I'm pronouncing this correct, but the point is that even the court took the exact same position. Here from the opinion, Congress is empowered to declare a general war, or Congress may wage a limited war, limited in place, in objects, and in time. And then we learn how the court viewed the legal status of each version. If a general war is declared, its extent and operations are only restricted and regulated by the jus belli, forming a part of the law of nations. But if a partial war is waged, its extent and operation depend on our municipal laws. TLDR, if you declare an open war, we declare war versus blank. That means you only need to follow the laws of war under the law of nations. So people like Vattel and Grotius, Burlamaqui and Wolfe, and many of the other people that the founders considered the pantheon of the laws of war, of foreign policy, the law of nations. And if it's a partial limited war, like what happened with the French, then you have to follow the municipal law. And that was the question that the court also asked. So then what's the nature of this contest between America and France? Well, in my judgment, wrote, I think this is Justice Chase, might be Washington, it is a limited partial war. Congress has not declared war in general terms, but Congress has authorized hostilities on the high seas by certain persons in certain cases. And this is far more limited, so different than what basically anyone describes as the war powers under the Constitution today. So I think we have a huge takeaway. Ocean shipping routes can absolutely be protected and defended, and at the same time, you can also follow the Constitution. President John Adams absolutely proved this, and the scale of this was not small, it was enormous. We're talking about they may not have had the most powerful navy on Earth, but this is one of the great powers of the entire globe. France. They had been attacking American ships, seizing hundreds of vessels by the summer of 1797. Yet, even under that situation, President Adams didn't say, I got to just do whatever the people elected me to do and protect them. He consistently deferred to Congress beyond doing anything that went beyond the principle of repel force with force. And as even big government-loving Alexander Hamilton, plus the Secretary of War, James McHenry, they also agreed with that anything beyond using force to repel an active attack falls under the notion of reprisals and requires authorization from Congress. And over a 3-year plus year period, 1797 through 1800, Congress passed at least a dozen acts, I think it was like 14, it may be more, dealing with the situation, the war with France. And once Congress acted, President Adams did only what they authorized, stayed within the limits of what they established. And I think this absolutely destroys basically every argument we hear today from people who claim that a president has almost total unilateral authority to do basically whatever he wants to protect shipping lanes or respond to maybe potential attacks or previous attacks. Ultimately, the military battles with France, the war itself really was a stalemate. But because John Adams strictly followed the Constitution and defended commerce at the same time, this was a huge win for the United States. I don't know about you, but I never learned any of this, not a lick of this in government-run schools when I was growing up. I really had to seek it out on my own. And we're doing our best here at the TAC to really try to provide this kind of information to more and more people. We work hard every single day to reach and teach more and more people about the Founders' Constitution and how they put it into practice and how we're supposed to defend it, whether the government likes it or not. They certainly do not. And nothing helps us do this work more than the financial faith and support of our members. If you got a couple of bucks of that dirty government fiat, please consider throwing it our way. Our membership program starts out at just $2 a month. 10thamendmentcenter.com/members. That's all spelled out. We also have annual, 5-year, and lifetime options. Again, 10thamendmentcenter.com/members. Or if you don't want to join anybody as a member, that's super cool too, but you still want to help us out financially, I would absolutely love that. Or if you're already a member, which is even more awesome, thank you so much, and you want to pitch in a little bit more, no pressure at all, but I want to make sure you know where you can do that. That's 10thamendmentcenter.com/donate. I'm not going to belabor that point. I should mention that I'm not going to have a show on Monday next week. It's just going to be Wednesday and Friday, and we are really on a 2-show-a-week schedule now. So I'll let you know as things go what days we're going to be doing episodes next week, Wednesday and Friday. I do hope you enjoyed this. And if you want to help us spread the word, there's a number of other things that you can do to kind of trigger the algorithms, especially of the mainstream platforms, like leaving reviews on Apple Podcasts or any other podcast platform, comments in the archive, subscribe, get notifications, and things like on YouTube, for example, the more watch time percentage, the more likely the algorithm will show us to more people. So if you're at 150%, you let the thing keep rolling, that certainly will help out a little bit. So I really appreciate any consideration you can give to support us in whatever way works best for you. Thank you so much for being here. I hope you enjoyed this information. I hope you enjoyed the episode. I hope I made it at least a little interesting and entertaining here and there. It's really deep and important stuff. And that's why, more than anything, I hope it made you think, and I hope you learned something. Again, I really appreciate you being here. I hope you have an awesome weekend, and I look forward to seeing you next week here on the Path to Liberty.